Good evening, namaste to all the members present here. We are all gathered here for study circle meeting on SBO Declarations, and we have CS Vivek Hegde with us for that. And can I request CA Ramesh sir to escort the speaker onto the dais and then welcome him with floral bouquet. Thank you, Ramesh sir. I have a privilege in introducing today's speaker. Mr. Vivek Hegde is a fellow member of Institute of Company Secretaries of India and also a cost and management accountant. He is a practicing company secretary and having over 15 years of experience. Areas of practice include company law and FEMA. For 8 years, he has actively served ICSI as a member of Managing Committee of the Bangalore chapter of ICSI. Additionally, he has made significant contributions as a member of various subcommittees within Bangalore chapter of ICSI. He was the chairman of Bangalore chapter of ICSI for the year 2020-21. He is passionate about sharing his knowledge and expertise. He regularly serves as a faculty member for various programs conducted by Bangalore chapter of ICSI, including MSOP, EDP, and other seminars for both members and students of ICSI. His commitment to knowledge sharing extends beyond ICSI and has been invited to speak at numerous events organized by other institutes, including Institute of Chartered Accountants of India. He was part of the working group of ICSI on drawing revised guidance notes on secretarial standards in the year 2020. He was a member of editorial advisory board for monthly journal of ICSI, the Chartered Secretary. With this brief introduction, I present before you CS Vivek Hegde. Over to you, sir.
Very good evening to all.
Good evening.
Yeah, I was, as sir said, I was in management committee for 8 years, so I can understand the challenges in having study circle. That too after COVID, but all are used to seeing the screens, online sessions. So now people are a little lazy to come out also. And of course, if there is a reasons like rain and other things, that issue is there. I can understand, but that doesn't matter. Number doesn't matter. So whoever is attending, I will. Yeah, correct. So I try my level best to give justice to the topic whichever is assigned to me. So this is a new concept, SBO Declaration. For our company secretaries fraternity also, this is still a complicated subject because lot of concerns, lot of open issues are there here because this is a new concept. This concept was not there at all under the Companies Act 1956. This is a new concept altogether under the Companies Act 2013. That too it was brought in the Act, but finally the rules were implemented only in the year 2019. So it took almost 4 or 5 years to implement the rules of this significant beneficial ownership. Before it was implemented, again it has undergone few changes which was originally notified. So what is this significant beneficial ownership? So nowadays also if you are familiar with opening of bank account for any of your clients, you will get so many documents. One of that is beneficial ownership declaration. We say that declaration is more complicated than Companies Act SBO provisions because half of the things you will not understand. You will say here get the signature here. We will mark it and get the signature. And in case of foreign clients, it will be struck because they will ask so many questions. Even bank is also not able to answer what it is. So
even the subsidiaries, like the shareholders, and
you are right.
They will ask, but they will not give us.
Exactly. That's where in case of foreign companies, foreign director signature, we will strike. So that concept is there now everywhere, even for opening of bank account, even for changing the signatories. Everywhere they are asking this declaration, but that is almost concept is same, but provision wise this is different. Okay, so I just touch upon two slides to give an overview why it is introduced. As I said, it is introduced first time under the Companies Act, and transparency is the object, because people who is behind the scene should be seen to the corporate world. That is the whole objective of it. Because they will create so many complicated structures so that real identity of any of the company is not known to the public. So to uncover those ultimate beneficiaries of any company, this concept is introduced. And also you would have heard this FATF, Financial Action Task Force. This is an organization founded in 1989 on an initiative of G7 to develop policies to combat money laundering and to maintain certain interest. In 2001, its mandate was expanded to include terrorism financing. So that is the basic idea based on which FATF, India is also a member of FATF. So as a part of it, recommendation 24, there is a recommendation 24, there this concept was introduced, and since India is a country, India has implemented these provisions. This is the background to it.
So, is this different from FATCA? This is different from FATCA?
Yes. Different. That's what. That is different. This concept is different. Though the concept is same, provisions are different. Okay. So these changes aim to close loopholes and regulatory weaknesses that have allowed fake companies to facilitate criminal activity and tax evasion. So ultimately, who is behind the scene should be seen. That is the whole idea of it. And there was a parallel, or there was a related provision even under the old Companies Act. The beneficial ownership used to file. There was some. Now it is MGT6, MGT4, MGT5. Those two declarations. That is also beneficial ownership, but where the declaration will be filed, nothing will be behind the scene. So that is different. That is section 89, this is section 90. Okay, so this is the basic concept. And this is also for the investigator, because you are hearing so many scams happening. For any of these investigations to go behind the real culprit, this will enable the regulators or investigators, whether ED or ROC or whoever it is, to swiftly and easily identify the true beneficial owners of the companies, and thereby aiding the prevention and combat financial crime, corruption and tax evasion by supporting sustainable economic growth. So this is the concept, and all G20 countries except Japan and Canada are having this ultimate beneficial ownership laws. This is not, India is not the first country. So all G20 countries, there are about 39 countries have adopted this SBO Declaration concept. So this is not new, everywhere it is there, all countries it is there.
What is their objection, sir? Japan and why they are not done it?
Yeah, they may be having their own reasons. I don't know what is the reason, but they are not implemented so far. Okay, so basic provisions we will just touch upon. Section 90 of the Companies Act. There are 12 subsections in that section 90. Provisions wise it is very crisp, but complexity is more. And when there is a section, there are attached rules to it. These rules, which was introduced long back, then one set of rules have come in 2018, which was not implemented. Again, it got amended. Then in the year 2019, it got implemented. So there is a significant beneficial owner rules. We will look into it. Okay, so this is the basic framework of provisions. Easy to refer. Because it's a new concept, there are not much precedents. We have only 4 or 5 years of history for it, nothing more than that. Okay, so let us touch upon section 90. If you have any clarification, you can stop me in between, no issues. Okay, so section 90 subsection 1 says, every individual who acting alone or together or through one or more persons or trust, including the trust and persons resident outside India, holds beneficial interest of not less than 25% or such other percentage as may be prescribed. So here the section says 25% of beneficial interest he should have. But rules has diluted it. They have prescribed 10%. So this 25% for now you can forget. It is 10%. So main criteria is the person should be an individual who should have 10% beneficial interest. How again is a big question. It says acting alone, together, through one or more persons, trust. So that is very vast. It is not that direct beneficial. There are prescriptions given in the rules. We will get into it a little later. So ultimately the percentage is 10%. In shares of the company or right to exercise or the actual exercising of significant influence or control as defined in clause 27 of section 2. So here also it is not only through shares. Some of the beneficial interest may be held through shares, but it is not necessary that he should be a shareholder. Without being a shareholder also, if the person is exercising control on a company, that is called significant beneficial or significant influence or control. That is also defined what it means. Even in that case also, he will be considered as significant beneficial owner. We will get into the details later. So it is not only the shares, even without holding shares also, it is possible that some person may be controlling the company. Okay, so that also we have to get into it. Okay, shall make a declaration to the company specifying the nature of his interest and other particulars in such manner and within such period of acquisition of beneficial interest or rights and any change thereof as we prescribed. So ultimately the first provision, what it requires is the X, the person who is the beneficial owner holding more than 10% stake, directly, indirectly, we will come to that later. He should make a declaration to the company. That is the first requirement. He should make a declaration to the company, and that declaration is called BEN1, BEN1. That is a declaration. It's a simple, like your MBP1 DI rate, a simple 2-page declaration where he should give the details. That is the declaration he should give it to the company. So this is the first requirement, and central government may prescribe some exemptions. That is no, so far there is no such exemption, but this is the first provision. Okay, so we'll get into, we'll just open the form also a little later point in time. Okay, so now we will get into the next, some of the definitions, whatever is defined. Control is used in first subsection. If a person is exercising control on a company, what does control mean? So control is defined in Companies Act. Control shall include the right to appoint majority of directors or to control the management or policy decisions exercisable by a person or persons acting individually or in concert directly or indirectly, including by virtue of their shareholding or management rights or shareholders agreement or voting agreements or in any other manner. So last word is important, in any other manner. So it is a very, very inclusive definition. It can cover anything. It need not be any agreement also. Without there is any written agreement, without any shareholding, a person, if it is proved that a person is controlling any company, he is deemed to have control on the company. It happens in many companies, in the group companies where there is a MD or family-owned business. If there is a company formed, they will make 1 or 2 employees as directors. They will ask them to get the deal. They will ask them to become a director, somebody else as shareholders. But ultimately, they will be the people who will be running the show. So that kind of, there are so many such things are there. Okay, so that is why this is defined. Next is majority stake is defined. This is relevant for next provisions which I am explaining. So for now, we will see what is majority stake. Majority stake means holding more than 1/2 of equity share capital in a body corporate. This is simple. Second category is voting rights. First one is equity shares, 50%, more than 50%. Voting rights more than 50%. And third one is having the right to receive or participate in more than one half of the distributable dividend or any other distribution by the body corporate. So these three categories where they have defined majority stake. This is relevant for next slide. Then partnership entity they have defined. So partnership entity means a partnership firm registered under the Indian Partnership Act 1932 and a limited partnership. So here important thing is, because it's not only a concept of conventional partnership firm, LLP is also included in partnership entity. So these two they have included. So that is why this definition is important. Okay, we'll just move to next. This is the a very exhaustive definition under the provisions. This is very important. If this is understood, rest of the provisions are very clear. So who is significant beneficial owner? So to ascertain, or if we want to ask somebody to give a declaration, or if somebody wants to give a declaration on his own, first he should be clear whether he is SBO. Only if he is SBO, he should give a declaration. So that's why who is SBO is the main question. So that's why an exhaustive definition is given with explaining with various aspects of it. First thing is SBO in relation to a reporting company means an individual referred to in subsection 1 of section 90 who is acting alone or together or through one or more persons or trust possesses one or more of the following rights or entitlements in such reporting company, namely. So this is how the definition starts. First thing is, I am a reporting company, ABC Limited. So in my company, if we say that some person is SBO, then what are the things we have to see? So here they have listed it out. First one is holds indirectly or together with any direct holdings not less than 10% of the shares. This is the first condition, that individual holds indirectly. So indirect holding is must, not a direct holding. If he is directly holding 10% of the shares, then there is no concept of SBO because his name is known. If you file MGT7, his name is known. Everywhere his name is known. We don't have to find out somebody who is SBO. So that's why indirect holding is, we have to say. Let us say even if the indirect holding is 1% and he is directly holding 10%, then total will be 9%, 11%. In that case, he is SBO. So it says holds indirectly together with any direct holding. Both together we have to calculate. Without having any indirect holding, he is not SBO. That is the first category. Second category is conceptually it is same. Here it is voting rights. Holds indirectly or together with any direct holdings not less than 10% of voting rights in the shares.
Sir, here,
Yeah.
when you say acting in concert with others,
Yeah.
which means others also have to give the declaration.
Yeah.
I am acting. I have the
Correct.
mouth act.
Correct.
Somebody else also with me.
Correct.
So he also has to give the certificate.
Yeah, exactly. So you have given a declaration. You have given a declaration. For example, this question comes in case of husband and wife. If both are holding shares, let us say, in an example, they are holding
7 and 5%.
7 and 5%. That is indirect holding. Let's assume that they both are it's indirect holding.
How will you define the indirect holding?
Yeah, indirect holding there are below there are definition. I agree with that. For his question, you are right. So from wife side also, together with husband, she is holding more than 10%. From husband side, he is also together with wife, he is holding more than 10%. In that case, both of them have to give. Both of them have to give. Yeah.
But is it relevant in case of a private company and all that?
Yes. So this provision's applicability is for all. There is no exception. Exemptions are there. I will come to that specific exemptions in the last slide. But generally it's applicable for all companies, small companies, other than small companies, private companies, public companies, all companies, the provisions are same. There is no differentiation at all. Okay, we'll just move. So third one is again has right to receive or participate in not less than 10% of the total distributable dividend or any other distribution in a financial year through indirect holdings alone or together with any direct holdings. So this is the three concepts again they have made. Fourth one is has right to exercise or actually exercises significant influence or control in any manner other than through direct holding alone. So fourth one is without any shareholding. As I said, significant influence can be influenced. I mean, SBO can be even without shareholding. Here they have defined significant influence and control. Without shareholding also, if there are any possibilities that Mr. So and so is controlling this company, then he should give a declaration. Okay, so now indirectly, your question. So what is indirectly? Explanation 1. For the purpose of this clause, if an individual does not hold any right or entitlement indirectly under subclauses 1, 2 or 3, he shall not be considered as a significant beneficial owner. That is clear. So indirect holding is must. Direct holding, we don't have to worry. What is direct holding? I have subscribed to the shares. Share certificate is issued in my name. That is one case of direct holding. Even there is another case of direct holding where we have, I'll come to that. So, yeah, they are defined here. First one I have already covered. Shares of a reputed company represented such right or entitlement are held in the name of the individual. Direct holding. I have the share certificate in my name. My name is entered in the register of members. That is first case. Second case is individual holds or acquires beneficial interest in the shares of reporting company under subsection 2 of section 89. That is MGT 6 B5. We take MGT 4 from beneficial owner, MGT 5 from registered owner. We file MGT 6 with ROC. Reporting is already made. That is also considered as direct holding only. In that case also we won't have to look at section 90. These two are direct holdings. Along with direct holdings, if he is holding any indirectly if he is holding any percentage, put together if it is more than 10%, then there is a question of SBO. Okay, so now we will see what and all will come under indirect holding. Explanation 3. For the purpose of this clause, an individual shall be considered to hold a right or entitlement indirectly in the reporting company if he satisfies any of the following criteria in respect of a member of a reporting company, namely. So these are the categories they have given. First category is where member of reporting company is a body corporate, whether incorporated or registered in India or abroad, other than LLP and the individual. So I am ABC Limited and there is a body corporate which is a shareholder, and that there is an individual who holds majority stake in that member. I will give the examples also that so that it will be clear.
So holding company, subsidiary company, right?
Yeah, it will come. It will come. There it will come. We have to trace back. Suppose I am a subsidiary in India. There is a holding company in US. We have to see the shareholding of US company. In that US company, if there is any individual who is having majority stake, individual, only individual. Majority stake is already defined. What is majority stake? More than 50%. Then he is SBO, straightforward case. They will again layer it. That foreign US company will be again owned by another company, like that another company. They will layer it. Then we have to go back to wherever we find an individual who is controlling. That example I will get it. Okay. So this is the first simple case. Second case is holds majority stake in ultimate holding company, whether incorporated, registered in India or outside India, of that member. The example I said, Indian subsidiary, there is a foreign holding company which is in US, which is again owned by another company in Australia. That company is again owned by another company in Singapore. then that Singapore company will be ultimate holding company. That ultimate company is owned by one individual who is having 60% in that company. That company should give declaration. Okay, so you have to go till that. Yeah,
So if you say that there is a layering in between,
correct.
so which company we need to see the person is having majority, because and as you say that in our case,
Yeah.
US entity is holding majority. So maybe other entity will not be having, Australian entity would not have majority stake in US also. There may be cases.
No, definitely. If the chain is broken in between, then there is no requirement of going further. If I have the example, it will be clear. So this is the first case. Concept is understood, no? Okay, so I just here. Okay, so Vivek directly holding 8% in ABC Limited, ABC Private Limited. Direct holding. I am the shareholder, share certificate in my name. And XYZ Limited is a shareholder of ABC Private Limited. This is a company which is a shareholder holding 5% shares. 5% shares it is having. And I hold 61% in XYZ Limited. Okay? So what is my total holding? 13%. Direct 8%. Direct 8%. Indirect 5%.
How sir 5%?
No, 61% of 5%.
5%.
No. That is not the way to calculate.
Oh.
Earlier provision there was the way.
Ah.
Now it is not there.
Oh.
So long as you are holding majority stake
Entire 5 will come.
in that ABC Limited, XYZ Limited, I am the majority stake 61%. Entire 5 will be added to my direct holding. Okay.
Oh, we have done the other way around.
Yes.
We have taken 61% of 5%.
No. Earlier this was the confusion. It was there in 2018. Later they have amended and now this is how it is. So 13%. In the same example, suppose my direct holding is say 4%. Then it will not hit because total will be 9% only. Okay. So this is the simple example. Clear, no? So now I have to give declaration in when 1 to the company. Okay, so this is the simple example. Next example is Vivek directly holding 8% in ABC Limited, ABC Private Limited. XYZ Limited is a shareholder holding 5% in ABC Private Limited. Same example. The change is XYZ Limited is WOS, wholly owned subsidiary of PQR Inc. USA. Again, layering starts there. That is wholly owned subsidiary. Okay. PQR Limited USA is WOS of Pink LLC USA. Again, another layer. And I hold 61% in Pink LLC USA. That is ultimate holding company. So my direct plus indirect holding is 13%. So I should give a declaration. So even in this example, even if XYZ is not WOS, let us say PQR holds only 51%, or Pink LLC holds only 51% in PQR. Even in that case, same logic. There is no, it will not change. In case, let us say Pink LLC holds 49% in PQR Inc., then that chain breaks there. We don't have to go further. Even though I am holding 61% in Pink LLC, there is no SBO. Clear now? Okay, we'll move to next one.
61 above 50 it will considers.
Yes, above 50. It may be 50.5.
50.
Also.
It will be exactly 50 means
Exactly 50, there is no
more than 50.
majority stake.
More than.
It says more than in all the definition, whatever we saw here, majority stake. Holding more than one half. Holding more than one half. Okay, so that is the concept even for subsidiary holding also.
Sir, here, if XYZ Limited
Yeah.
owns 12% of ABC Private, then Pink, and there is Pink LLC.
Now
The
come
chain is
again.
broken into Pink LLC. You have to give a declaration.
Now come again, sir.
XYZ Limited
Huh.
holds 12% of ABC.
ABC, okay.
Now Pink LLC,
Yeah.
they have the chain breaks. I mean, it's not connected with Mr. Vivek.
Huh.
Pink LLC is the only owns, only owns PRQ Inc.
Okay.
Then they have to declare declaration.
No, individual. The
Okay, any person having
Huh.
majority shareholding in Pink LLC has to give.
Exactly. If he is holding
More than
50. So SBO can only be individual.
Okay.
So nobody else, only individual. It says it starts with that only.
Yeah.
It should be an individual. Add the individual. Okay. Okay. So that is the body corporate case. Body corporate includes foreign companies in India also. Body corporate, private company, public company, it all includes. Okay. LLP is again there is another category there. There the concept is different. Okay. Next category is HUF. In case of HUF is a shareholder in my company, then it is straightforward. It is nothing to do with these calculations. The individual is karta of HUF. So long as he is a karta of HUF, then this calculation is simple. I hold directly 8%. I am karta of Vivek HUF, and that HUF is holding 5% in ABC Limited. Then this simple calculation, 30% I am holding directly plus indirectly. So I am SBO. I have to give a declaration.
So this responsibility to give the declaration.
Huh.
I mean, if somebody probably staying in Japan, somebody in UK, how will he know that?
Exactly. That provision is there. That is the most complicated provision in this thing. That is another very important topic. I will cover that.
So then I want to, can you please go back? There was a question back.
Yeah.
So like here in this case, Vivek HUF is holding 5%. Now there is a middle layering in between. There is one company in which Vivek is holding some of the shares and Vivek HUF is holding some of the shares. And
No, come again. I'm not getting that. Yeah.
so there is a one company in between. There is a one layering.
Okay.
ABC Limited is 5% is held by XYZ Limited.
Okay.
And XYZ Limited, Vivek is holding 30%, let's say.
Okay.
And Vivek HUF is holding, let's say, 21%.
Okay.
And Karta is Karta of Vivek HUF is that person.
Okay.
So now how will we calculate that majority is held by them together with that?
Exactly. So that concept again will come there. So together you are saying it is crossing 50.
Yeah, because if we consider Vivek HUF.
Exactly. Together you have to see. Because again, if you see here, majority stake definition, I'll just show you. Yeah, control will come into picture there. Directly, indirectly. Acting together, or so those concepts again will come. But practically, these provisions are there. For example, this kind of wordings are used in many acts. Acting together, directly, indirectly, accustomed to act. These are all the words which the regulator has put into some eventuality if that is required for any investigation, unless it is established by somebody. Just because I am husband and wife, that does not mean that they take decision together in the current society. Just because it is held by husband and wife, it cannot be said that they are acting together. Both of them can be taking investment decisions individually in the same company, possible. So that's why all these things should be established. Just because they are holding together, just because they are brother and sister, you cannot say that they are acting together.
Actually, in our case, our company is an Indian subsidiary.
Yeah.
Holding company is a German company,
Yeah.
holding 99% shares.
Yeah.
On that German company, Swiss company is a ultimate holding company.
Swiss companies.
Swiss company, Switzerland, the company incorporated in Switzerland. The Swiss company is a listed company. All this.
Exactly. In
all
listed
the-
company cases,
Yeah.
listed company cases, generally the shareholding will be diluted unless if there is a family, because in India it is called a person acting in concert or something in SEBI regulations. if there also if there is such concept, if there is a family which is owning more than 50%. In India there are many such listed entities where family still owns majority stake. If that is, unless that is established, we cannot say that there is a SBO.
SBO will not.
Yeah, many cases, we have many such cases. Finally, in the listed company, shares should be diluted. There will be no individual who is holding more than
51%.
more than 50%. Okay, that is
That
a.
means that SBO.
But there the challenge is getting the information is also challenge.
Getting information is the biggest challenge.
That is the challenge. So many, that is the common issue we have. They will say why I should share.
Yeah,
It is
exactly.
confidential. So that is why we get struck there. But we will see what the implications are.
Sometimes the holding company's shares are held by a mutual fund or
Correct.
an investment fund,
Correct.
and they don't want to give the details
Correct. Correct.
of who those contributors are.
That issue is there. Correct.
So how to do all this thing?
Yeah. Yeah. So what we have to see from company side, what we have to do, that is we have to do. If it is not there, consequences are there. I'll just tell you. So far, this is a new section. It has not gone up to court so far. Okay. But we will see. Over the period, I think something will develop. Okay. So now, body corporate shareholding we have covered. HUF shareholding we have covered. Third one is partnership entity. Partnership entity includes traditional partnership registered under 1932 Act as well as LLP. Both it is covered. So if the LLP or a partnership is a shareholder in the company, then the individual is a partner. Or, so first case, so long as he is a partner, he is SBO, irrespective of partnership stake. It is not saying you should have majority partnership profit sharing ratio, nothing of that sort it is saying. So long as you are a partner, even with very minute stake also, he is SBO.
But there will be many partners, so all of them will become
Yes,
SBO?
yes. In SBO, in partnership, there is the challenge.
So,
All the partners should be.
LLP also.
LLP also, you are right. LLP both are same.
So all
Yes, yes. Okay. So, B, that is one category, holds majority stake in the body corporate, which is the partner of partnership entity. So, there is a partnership entity where there is a body corporate which is a partner. Then the person who is holding majority stake in that body corporate is the SBO. C, holds majority stake in ultimate holding company of the body corporate, which is a partner of partnership entity. Again, partnership, there is a partner who is body corporate, which is again owned by another body corporate, again another body corporate. Then we have to go up to ultimate
individual.
holding company, which is owned by an individual who is holding majority stake in that. So we have to go till that. Okay, so here the examples are, I put very simple examples. Again, same 8% directly holding. And I am a partner of Vivek and Co, a partnership firm. And Vivek and Co is holding 5% in ABC Private Limited. Okay, so there is a partnership shareholding. I being a partner, the 13% will be the total stake.
But in this case, other partners of Vivek and company don't have to give, because they don't have that.
Direct holding they don't have.
That's 8 only.
8%, correct.
5 only, sorry, there are only 5
You are right, you are right. Of course, in this example, assuming that
Yes.
they don't have. Yeah.
Yes.
I have
This
to
8 is not available or not applicable for the other partners.
correct, if they don't have direct holding, you are right.
Now here you have not mentioned what is your holding in Vivek and Co.
Exactly. That is irrelevant.
Irrelevant.
So long as I am a partner,
You are becoming.
yes. That is the difference between body corporate and partnership entity. The individual is a partner. That is the only condition.
That is only.
Whether what is your profit sharing ratio, all these things are irrelevant. Okay? We'll go to next
And
slide.
even the status, whether sleeping partner or active partner, that status,
No, that's not.
that does not
No,
matter.
not at all. That doesn't matter. So long as you are a partner, you are SBO. That is how it is. Okay? So this is next example. Vivek directly holding 8%, same thing. XYZ Limited is a partner of Achar & Co, a partnership firm. Achar & Co is holding 5% in ABC Limited. And I hold 61% shares in XYZ Limited. Okay. So now,
Yes.
this is clear, no? So total 13% again, because I hold 61% in XYZ Limited.
If you hold 40%, then you are not a SBO.
Yes, you are right. Because that is the ultimate second condition which is there. You have to go up to the last layer. If the chain is broken in between, then you don't have to go further. So this is one more example. Again, I directly hold 8% in ABC Private Limited. XYZ Limited is partner in Achar & Co, a partnership firm. Achar & Co holds 5% in ABC Limited. Vivek holds 61% shares of DEF Limited. DEF Limited 78% in GHI Limited. Again, GHI Limited holds 99% in XYZ Limited. So like that it is layer. So finally we have to see ultimate beneficial owner. So in between, if there is, suppose in DEF Limited I hold 49%, then that's the end. We don't have to search for any SBO line.
But even 49% is also there, but finally Vivek in Achar & Company, some share will be there, no?
No. Where Achar & Company,
Some percentage will be there, no, at least. In that case, Achar & Company is a partnership company. So, he said,
no, if it is there, here it's not disclosed. This example,
Yes.
nowhere I am the partner. This example, nowhere it is, as per the information given here, I am not the partner of Achar & Co.
Not direct.
I am not.
Direct.
Yes. Even indirectly also, I am not a partner here. Yeah.
But still you are a
Yeah.
SBO.
Where? In this case?
In this case.
In this case, because
Yeah, what
because of my
Sure.
holding in DEF Limited, which owns GHI Limited, which again owns XYZ Limited, which is partner of Achar & Co. Like that, SBO is established. But without these companies, only Achar & Co. Achar & Co, if not me, definitely there will be others.
Yeah.
If they hold, okay, definitely there will be SBOs there. I am not SBO, that is why I am saying. There will be SBOs because they are holding 5%. Irrespective of, unless they hold another 6%, let us say, to constitute more than 10%, then there is SBO. Yeah. So that is, we have covered body corporate and HUF and partnership entity, which includes conventional partnership as well as LLP. Now the trust. Where the member of reporting company is a trust through trustee and the individual. So this is, trust holding is very common nowadays in VC funding cases. In India also there are so many trust which are investment funds. So there the condition is trustee in case of discretionary trust or charitable trust. So here also three categories. In case of discretionary trust or a charitable trust, trustee is the SBO. In case of specific trust, the beneficiary is the SBO. In case of revocable trust, author or settler is the SBO. That is how they have categorized these trusts. Again, it's all definitely you are aware of these categories. So discretionary trust means where the trust, if the income or any part thereof is not specifically receivable on behalf of or for the benefit of any one person, or where the individual shares of the beneficiaries are intermediate or unknown, that is the discretionary trust. In discretionary trust cases, trustee is the SBO. In case of charitable trust also, where the trust is designed for the benefit of public, there also trustee is the SBO. In case of specific trust, then in that case it is beneficiary. Who is the beneficiary of that trust is the SBO. In case of revocable trust, trust where the settler transfers the property to a trust, under such provision that any part of the income or assets so transferred may be transferred to the settler, or where settler has received the powers to reassume control over the trust property. So in that case, it is the settler or the author is the SBO. This is as far as trusts are concerned. We should get the clarity first on the nature of trust. Then we can identify who is the SBO. Okay, so this is again same example. 8% directly, and I am a beneficiary of PQR Trust. PQR Trust is holding 5% in ABC Limited. Trustee has made declaration under 89 stating that UAT's declaration. Now this is again another small twist here. As far as trust is concerned, if that direct holding we have already explained, if there is a declaration is made under section 89 that by filing MDT 5, MDT 4 and MDT 6 with ROC, already the beneficiary is declared. Again, we don't have to search for SBO there. So in this case, even though total percentage is more than 10%, there is no indirect holding for me, no SBO. Okay, so this is also, if there is a 89 compliance is made, that is considered as direct holding. Okay, so then fifth category, where the member of reporting company is a pooled investment vehicle or an entity controlled by pooled investment vehicle. So this is a new concept again in investment, VC investment, this kind of investment funds are also there, pooled investment vehicles. So
Any mutual fund also will fall under the category of pooled investment vehicle.
Come again, sir?
Mutual fund also will fall under the category of pooled investment vehicle.
Yes, definitely. So there we have to see the country first. If the pooled investment vehicle is based in the member state, that is again FATF will come into play there. Financial Action Task Force on Money Laundering. If it is from a country which is a member of that task force, and the regulator of security market in such member state is a member of International Organization of Security Commissions, and individual in relation to the pooled investment vehicle. So first we have to see the country, then we have to see whether that country is fulfilling this condition. Because ultimately all these provisions are from there only. It is from FATF only. That is why these provisions they have brought in. If it is a member country, in that case, the general partner of that pooled investment vehicle is SBO, or is an investment manager. If the individual is an investment manager of that pooled investment vehicle, he is SBO. And in case that investment manager is a body corporate or a partnership entity, in that case, CEO of that investment manager is SBO. This is the first category of pooled investment vehicle. We get hardly few categories we will get. Okay, otherwise everything will go into body corporate category only in case of foreign investments, but we have to see. And another category of pooled investment vehicle is other than those countries. If that particular country from where the pool investment vehicle has invested, if that country is not within the jurisdiction of this FATF, then same concept will follow, whatever we explained earlier. We have to consider it as a body corporate, and same calculation will be done. So these are the categories they have made to identify the SBOs. Complexities will be there, challenges will be there to identify. Even in domestic companies also there will be challenges. When it is foreign company, definitely there will be challenge. Okay, so of course lot of explanations they are given in the rules. For the purpose of this clause, if an individual or individuals acting through any person or trust act with a common intent or purpose of exercising any rights or entitlement or exercising control or significant influence over a reporting company pursuant to an agreement or understanding, formal or informal, such individual or individuals acting through any person or trust as the case may be shall be deemed to be acting together. So again question will come because many places they have used acting together, acting together. They are just given, try to give some explanation. This explanation is also again will lead to a lot of interpretations. They said formal, informal. So such kind of use again. So it will again go into another loop. Informal, how will you establish that they are acting together? Okay. They try to give some explanation. Okay. So it is if it goes to litigation, again for the lawyers to interpret. Okay, so next is explanation 6. For the purpose of this clause, the instrument in the form of global depository receipt, CCPS, CCD shall be treated as shares. Yeah. Shares means not only equity shares, it includes preference shares also, compulsorily convertible. Compulsory convertible debentures also considered as shares because these are called quasi-equity, no? Convertible instruments are considered, should be considered by calculating percentage of voting rights, percentage of shareholding, majority stake, all these things.
Sir, you mentioned about litigation.
Yeah.
What type of litigation can arise in this?
Yeah, as far as provision on this, simple thing is recently many companies have received Ben 2 notice because artificial intelligence, no? Many companies have received notice that you have not filed Ben 2. So after receiving Ben 1 from the beneficial owner, company should file Ben 2. That's a e-form. Not filing of Ben 2, ROC has sent notice to many companies. Now you have to establish, you have to defend. If there is a penalty, then you have to go to our regional director, you have to explain that no, he is not SBO. Such kind of cases it will come. Definitely we have to argue, we have to, interpretation issues will come there.
So here also now when one we have to receive again in this also, in this case also?
In this case means?
For filing SBO declarations?
Yes, yes. First thing is getting it from the SBO.
Yes.
First we have to ask
Yes.
that provision, I will come to that because he on his own he will not know.
Yeah.
How a person will know that there is something, Ben 1 which I should give to this company, he will not know. So there is a provision that we should take step to make him understand that he should give. Okay, then he should give the declaration based on which company should file Ben 2, which is an e-form. Then again there is a register company should maintain. It's also part of statutory register now.
That is Ben 3, right?
Ben 3. And there is a notice also company should give, that is Ben 4. So all Ben 1, Ben 2, Ben 3, Ben 4, these 4 forms are there disabled. Okay, so Yeah, that's I've defined significant influence. I already
So
told.
2 years back also, this is made it compulsory, abandonment to
Correct.
filing it. No?
Correct.
Then what is this required again?
Okay, I'll tell. So if you see the first provision, I'll just go to that. The last line of first para, if you see,
Change.
change in such manner and within such period of acquisition of beneficial interest or rights and any change thereof. So there is a change concept also. So in the normal case, it may not come. Suppose my 13% may become 15%, or my 15% may become 9%, or whatever declaration I have given, my address may change.
So this is annual compliance,
Nothing like annual.
as and when.
As and when, there is a timeline also, but as you rightly said, once they have done, after that nobody is tracking it.
Correct.
That is the practical issue. Even we are also not tracking because somebody should keep an eye on it. See, whatever shareholding change, company will know. But if there is any other change, because ultimately the whatever declaration he gives, we should file it with ROC. That is important information. His address, all these things are very important information for any investigator to catch hold of it. If there is any change in address, we should give again another declaration. That how will company know? So all these are practical challenges. It's not like annual filing. It is as and when there is a change, it should be filed.
Once an SBO number is allotted to a person, to an investor,
Come again?
SBO number
Exactly.
after filing Ben 2,
You are right.
some SBO number gets allotted
Correct.
for that particular individual, right?
Correct. Correct.
So he can quote that number for other companies also if he has got investments in other companies.
Yes. Yes. Correct.
Say it's like a PAN number, right?
You're right.
One number,
You are right.
one person.
You are right. You are right.
But they generally don't know that. They apply.
That is another challenge. Even though we file the return from our login ID, that number we will not get.
Correct. We will
It
not.
will go to his some email ID, whatever he has given. Taking that is another challenge. Next time if there is a change, we will be searching for that number. That is it. That issue is there. Okay, so we'll just move to next. Significant influence means the power to participate directly or indirectly in the financial or operating policy decisions of the reporting company, but is not control or joint control of these policies. So again, another open-ended definition here. What is significant influence they have given? Ultimately, idea is to catch somebody who is behind the show, whether he is holding the shares or not, whether he is having any agreement to appoint directors or not. So whether he is influencing the decision, that's what they want to figure out.
But ideally, it should have been limited to big companies.
See,
Small company
that
has
is another big discussion,
10
sir.
crores turnover, what difference it makes?
I know. See, that is another very big debate. It is there. Not only this provision, there are n number of such provisions in the Companies Act, which is an overburden on a small company. But somebody should understand that, no?
Yes.
Yeah, they say we cannot tailor-made the provisions for.
We are saying ease of doing business.
Yeah, that challenge is there. That's the another debate, sir. It is there. Simple question. Now we are on the verge of filing annual returns. If you have a website, the annual return, MGT7 or MGT7A, should be uploaded on the website. Mandatory, no exception. That link should be given in your board's report. That is a simple provision. No exception. It's many companies are saying why I should upload. In the annual return, my salary will be disclosed. My employee will see. I don't want to disclose. So many such issues.
Competition will see.
Exactly. See, private company, that is the advantage so far we have been advocating, no?
Correct.
But that is not there now. It's there, of course, if anybody inspect MC website, you can get the annual return. But who will do that, take the strain?
Correct.
In the website, if it is there, everybody, vendor will see, everybody will see.
Correct.
So that is the major concern we have with all the clients. But no exception. Again, they say, why I am not a registered company, why I should upload. So they said, that is what is the provision, no exception. Like that, there are many provisions. Okay, so we just move to next. we have covered one subsection. Other subsections are very, very straightforward. Main concept is SBO we have to understand, then other things. So this section, subsection 2 is, again it's all about maintaining the register. There is a format of register they have given, Ben 3. Same details whatever is there in Ben 1, they have to enter and keep a register. That's what it says. Again, this register should be available for inspection by any member of the company on payment of such fee. This is straightforward. Yeah. What company is required to file, which is Ben 2. Section 90, subsection 4. Every company shall file a return of SBO of the company and changes therein. Both. You incorporate a company and one body corporate happens to be a shareholder, and there is a person who is holding majority stake in that body corporate. That's the first case you have to file SBO. Then subsequently, if there is a change, whatever I explained, that is another time you have to file SBO. So again, with the register containing names, addresses, other details as we prescribed within such time, is the section. As far as the rule is concerned, they have given little more detail. Upon receipt of declaration under Rule 3, that is upon receipt of declaration in Ben 1 by the SBO, the reporting company shall file a return in Ben 2 with ROC within the period of 30 days from the date of receipt of such declaration. So company timeline starts once you receive the Ben 1 declaration from the SBO. So company's responsibility is to file within 30 days. This is a e-form. Then 90 subsection 4A. This is the responsibility of the company. So if you ask what company should do, every company shall take necessary steps to identify an individual. So it is company's responsibility to identify the individual, to take steps. Company should take steps. What we do is, in first, whenever it is introduced, we send mail to all the clients. So body corporates holding so many percentage of shares, please get the shareholding pattern of that body corporate so that you can analyze the provisions and you can see that there is applicability. So such steps company should take. Okay, who is SBO?
Non-individual shareholders.
Exactly. If the shareholders are individual shareholders, then you don't have to think about SBO at all.
His name indirectly did.
Yeah. Okay. But if there is one shareholder, even though he is holding less than 10%, even though he is holding 1%, 0.5%, still we should search, because this may be indirect holding 0.5%. There can be another individual who may be holding majority. Put together it may be SBO. Okay, so that is the it is. So it is company's responsibility to take necessary steps to identify an individual who is SBO in relation to the company and require him to comply with the provisions of this section. So this is the company's responsibility. So questions again, we have sent mails, they are not responding, all these things are there. In many cases it will go for a year, then it will be left there, no action will be there.
Particularly foreign shareholders, they don't accept.
You're right.
Why should I do that? Why
It
should
requires
I
a lot of effort, I know.
Why should I give data?
Correct.
Drainage is confidential.
Yeah. So here what I said is, it is little tricky provisions are there here, but nobody is following it. But as far as this section is concerned, first responsibility I have already explained. Second responsibility is, again in the rules they have said, every company shall take necessary steps to find out if there is an individual who is SBO as defined in rule in the relation to reporting company, and if so, identify him and cause such individual to make a declaration in Ben 2. So it is company's responsibility. This is a general responsibility. Generally we ask the company to send email to the concerned person asking the details, that is the whatever reasonable steps company can take. We cannot force him to sign, but at least they can send email, follow up, so that if any regulatory action is there, he can show we have taken necessary steps. But he has not made the declaration. It's not our fault. Next is 90 subsection 5, related to that only. A company shall give notice in the prescribed manner to any person, whether or not a member of the company, whom the company knows or has reasonable cause to believe that to be a significant beneficial owner. If the company has knowledge that Mr. So-and-so is SBO, then they should send notice to that person. To be having knowledge of the identity of a significant beneficial owner or another person like to have such knowledge. So you don't have to be rooted to only SBO. A person who may be knowing the SBO. In many cases it is company. Because in case of a foreign subsidiary like yours, your holding company will be knowing. So this notice should be sent to them. Okay. C is to have been a significant beneficial owner of the company at any time during the 3 years immediately preceding the year on which the notice is issued. Okay, this is another category. If he was a SBO, to him also they can send, he would have transferred shares to identify. Okay. So here the tricky provision is here. So one is company has taken reasonable steps. Without prejudice to the generality of the steps taken under sub-rule 1. Sending mails or calling them, those steps. Every reporting company shall in all cases where its member other than an individual holds not less than 10% of its shares voting rights, right to receive, participate in dividends, give notice in such member seeking information. This is Ben 4. So here the responsibility is, so in the first case, even if the body corporate is having less than 10% also, we call them, so that step is one. In addition to it, there is a requirement of sending notice also in Ben 4, where in all cases where a member is holding not less than 10% of these shares, voting rights, right to receive dividend. This is the requirement. If it is 5%, 6%, 1%, that is, this step is not required. First step is required. This action nobody is doing. Okay, nobody have done also so far. This because if you take this step, there are subsequent actions. Subsequent actions means I'll just tell you what it is. The moment you send notice, there is a timeline starts. That opposite party should give the information sought within 30 days. If he has not given, immediately within 15 days we should approach NCLT. So the steps will start. So nobody have touched this provision so far. They are taking the first normal follow-up only they are doing. They have not taken this step. Whether this is a violation or not is a big question. If you are going by the plain reading, this is not an option. This is a additional step which company should take.
It's only for non-individual.
Non-individual. Non-individual holding 10%. If he is holding 1% and all, this step is not required. This step is required. 1% cases and all, first step is required. Okay. Okay, this is information required by the notice under subsection 5 shall be given by the concerned person within a period of not exceeding 30 days. So when we send Ben 4 notice to whoever concerned, he should give reply within 30 days. That is the timeline starts. If he has not given, company shall. So now company's responsibility is also there. Company cannot stop that. Where that person fails to give the company the information required by the notice with the time specified therein, where the information given is not satisfactory, reply to the tribunal within the period of 15 days of the expiry of the period specified in the notice. For an order directing that shares in question be subject to restrictions with regard to transfer of interest, suspension of all rights attached to the shares, such other matters as may be described. So, this is the consequence of Ben 4.
So there is one more form to find this, is it?
One more?
Form.
Huh.
Under section 97, when you are giving this information to NCLT, there is a form to fill up and give, submit and NCLT.
Yeah, NCLT proceedings, NCLT rules are there, where there are different forms are there. Under that only we have to. Any application to NCLT will have its own set of formats. Okay, so this is the timeline for the company. So, to the extent possible, so far in all these 3-4 years of
This is a dangerous provision.
dangerous provision, that's why one school of thought is this is only in the event if they have not given the last step which we should take. We should pursue the first step, we should follow up and get the information. That is the only thing which they are doing. But this is very dangerous because NCLT, if you apply, definitely they don't have any other option but to freeze all the rights of the shares. So that is a major implication in holding company cases and all. Impact will be very huge. It is a suicidal action if you do.
So that was really, to make it very simple, instead of applying for the tribunal and all, you directly freeze, they were told.
Yeah.
To make them, to act on the notice.
Okay, so this is the on an application made under subsection 7, the tribunal may, after giving an opportunity of being heard to the parties concerned, make such orders restricting the rights attached with the shares within the period of 60 days. Then also there is a timeline. Okay. 60 days timeline is given to NCLT also. They should pass an order. Okay. So that's why Ben 4, it is very risky provision if you start. Okay, we should see the consequences also, because in case of holding subsidiary cases and all, it will impact the whole business. It will be a very disastrous thing. Okay. Again, subsequent actions they have given. The company or the person aggrieved by the order of the tribunal may make application. Again, filing application to tribunal for relaxation or lifting the restrictions within the period of 1 year time they have given. Again, they have to make application. Then they will come, then they will be active, then they will make declaration and they have to again make application. So all these things will take time. So provided that if no such application, again there, even if 1 year time is given for you to make application and get the restrictions released from NCLT. If no such application has been made within a period of 1 year, then again this will go to IEPF. This case will go to IEPF. Okay. So till that they have made the provision. So starting Ben 4 is very risky as far as provisions are concerned. So ultimately the best option so far we have done is we have explained the provisions first to the company. Company also, you know, the resistance. Why we have to do is applicable to us? Are you sure that it's applicable to us? And then we should make them understand the seriousness of the provision. They should, whoever top officials, they should talk to. Otherwise, if it goes from lower level, nobody will react. Okay, so that way we have to make this happen. Penalty. If any person fails to make a declaration as required under subsection 1, so this is the penalty provision on the person, SBO. If he fails to make declaration under subsection 1, he shall be liable to a penalty of 50,000 rupees, or in case of continuing failure, with a further penalty of 1,000 rupees for each day after the first, during which such failure continues subject to maximum of 2 lakh rupees. This penalty nobody is worried. The most worrying part is the consequence of not giving declaration. Okay, this is on the person who is supposed to give. Then on the company and its officers. Okay. So here also there is a conflict now, because the person should give the declaration within so and so, within 30 days. He has given after 30 days. Then penalty provision will shift to him. So in this kind of cases where we follow up for 6 months, let us say, after 6 months he gives the declaration. Then as a strategy, what we do is we put the blame on him. We will say that we have received declaration today. My obligation to file Ben 2 starts now. Okay. So he has delayed giving the declaration. He should have given within 30 days. He has delayed it because this conversation will take time. Ultimately, it's delay from their end only. So we will shift the delay on them so that company is safe. If he gives declaration of backdated 6 months old declaration now, then company will be in violation. Okay. So if a company required to maintain register, so compliance is again. Maintaining register is also compliance, and filing of Ben 2 is also a compliance. If it fails to do so, or Danish inspection as provided therein, company should be liable to a penalty of 1 lakh rupees, or in case of continuing failure with a further penalty of 5,000 rupees per day. Of the first during which failure continues, subject to a maximum of 5 lakh rupees, and every officer of the company who is in default shall be liable to a penalty of 25,000. In case of continuing failure with a penalty of 200 rupees for each day after first, during which failure continues, subject to maximum 1 lakh rupees. So this is the penalty provision for the person who is required to make the declaration in Ben 1, and the company which is required to file the declaration in Ben 2 and other provisions, like maintaining the register or all these provisions, etc. So this was, I was saying, many companies have received notices for violation now. Okay, so now because of this V3 version you would have heard, many things they are trying to automate. So there is something called compliance management system they have built. It's not yet fully functional, but once it is up and running, all show cause notices will be received automatically in the email only.
V3 is only for LLP, right?
No.
No?
V3 is now for companies also. It has come. It has created a big mess, and still it's not stable. System is not stable. We are all struggling.
Last night Pro is maintaining it, right?
Come again?
Last night Pro is
Yeah.
writing information.
Implemented.
Yeah.
False or incorrect information. Subsection 12. If any person willfully furnishes any false or incorrect information or suppresses any material information of which he is aware in the declaration made under this section, he shall be liable under section 447. 447, they have linked it to many provisions now. It is a fraud related provision where the consequences are very, very severe, okay, including imprisonment and all. So that's why in investigation cases and all, this provision they will invoke. Okay.
These forms need not be certified by company secretary, right? When Ben 1 is given by the investor,
Correct.
Ben 2 is to
Correct.
be filed. Ben 2 is to be certified by the company secretary.
Ben 2 should be certified, yes. It should be certified. It should be certified.
Now,
Okay, sorry, one slide is missing. I just, exemptions, I think I have missed it. Okay, I just, exemptions is very important because so there are some exemptions which are given for this section is Yeah, if the shares are held by IEPF, if the shares are held, definitely you don't have to search for SBO. In many cases, shares will be held by IEPF where there are no claimants for the shares and all. Okay. Then holding reporting company. Okay. For example, in case of a company where I am a reporting company, I have a holding company. Holding company is Indian company, which is owned by another body corporate, which is owned by an individual, 50% or 52%. Then my holding company also should file this declaration, because for them also it's applicable. You understand my point? I am ABC Private Limited. XYZ Limited is my holding company. XYZ Limited, there is a body corporate shareholder who is holding 10%. And that body corporate is owned by one individual who is holding 60%. Then my holding company, which is XYZ Limited, also should file BEN 2. If they have filed, I don't have to file. If they have filed, I don't have to file. That is, this is relevant for Indian companies. If my holding company is foreign company, then for them there is no obligation, right, to file. But if in Indian group companies, this is relevant. If my holding company has filed BEN 2 in respect of that SBO, I don't have to file being a subsidiary. That is one exemption they have given.
But both also can file.
Huh?
Both also can file.
No, they don't
Who
have
has
to
filed?
file.
Ultimately,
Huh?
the
Yeah, if they have not filed, I should file.
Okay.
If they have filed, I don't have to file.
But they also have to file in any case.
They have to file in case they have missed. Chances, no? If they miss. Okay, then other cases are central government, state government shareholding and local authority shareholding. We don't have to search for SBO. Okay. Again, government related establishments they have listed. Important thing is SEBI registered investment vehicles. That is in VC funded companies is very common now. Many SEBI registered investment vehicles such as mutual funds, alternate investment funds, AIFs, real estate investment trusts, infrastructure investment trusts regulated by SEBI. These categories, there is no, you don't have to search for SBO, they are exempted. And the last category is again investment vehicles regulated by RBI or IRDA or Pension Fund Regulatory Development Authority. So these are the few exemptions they have given. You don't have to do SBO. Other than that, there is no differentiation between private company, public company. There is no such differentiation. These provisions are applicable for all the companies. Okay, so the
Banks are required to.
come again?
Banks.
Yeah, definitely. Definitely. That's required. There is no such exemption. Okay, so this is what the whole SBO provisions are about. To put it in simple terms, it is company's responsibility to take initiative to identify the SBO and convince him and get the declaration if at all he is an SBO, and to file that declaration with ROC in BEN 2 and maintain the register. In case, even after taking reasonable steps to identify the SBO, if it is not in a position to get the SBO declaration, then BEN 4 sending the notice, then all subsequent steps I have referred. Okay. So this is the whole structure of the SBO provisions. Clear? If there is any question, you can ask.
So is there any withdrawal provision is there?
Yeah.
Withdrawal provision, suppose consequent to change in the shareholding or what?
Exactly. So there are practical issues are there. For example, now this question always will come across. If we have declared it when we were SBO having 11%, then shares got diluted for transfer or whatever reason. we cease to be an SBO. But there is no such provision in the form to file that form, this one, to withdraw, as you said. There is no such provision. That is still a question mark only. How to withdraw, that is a question mark. Another question is, what is change is also a question. Whether my percentage from 13 to becoming 14%, is it a change? Or 13 to 9 is a change?
Threshold limit, once you
Yeah.
pass it.
So that is also because nowhere it is defined. What is change? Just change in my address is a change.
No, not change. Only SBO declaration. SBO declaration.
But again,
falls
for
within
example,
10%.
address is an important information to catch out of anybody whenever there is investigation or something. If there is a change in address, is it not a change to be declared? So all these questions are there. These questions are there. Yes, sir.
In our case, as I told you, we are a subsidiary in India. Our
Yeah.
holding company is a German company.
Yes, sir.
The holding company, ultimate holding company is a Swiss company.
Yeah.
That Swiss company is a listed company.
Correct.
And then obviously prima facie there is no SBO. SBO is an individual only, not a corporate, right?
Correct, correct. So long as in that listed company, as I explained,
Yeah.
if there is no one individual, he need not be individual, acting together and all.
Yeah.
In India, I explained the concept of, in SEBI there is a concept, no? In listed companies, person acting in concert. If there is any such family-owned listed companies are there, where family is owning more than 50%. Such kind of cases, there can be chances that there will be SBO. Other than that, there may not be any chance. In listed companies, it will be like that.
We take up the matter with our top manager. Go to the website, see that all the shareholders in the list, tell your MCA to go to the website and see that. Why should we give all the details? So this is simply they say that even though
That is, even in simple structure also, getting the information is very difficult.
I cannot go to the shareholders and ask, even CEO says that I cannot go and ask him, you signed in this long form, well known and all. Who are you to say that?
That is the practical issue, sir. It is not only in this case, many cases it is there.
So how to establish it directly, indirectly, said no, how together, all this, how it works.
Exactly. So that is also one more challenge. In case of Indian structure, we are clear how the shareholding percentage we have to calculate, how the voting rates we have to calculate. Because it is governed by Indian laws, we are clear. In foreign cases, establishing whether a person is holding majority stake or not, that itself is difficult. Because there the structure will be different. There also it may not be a company form also. Suppose ABC LLC. LLC means limited liability company. It can be owned by one person. That is the majority cases is like that. It can be different set of LP, limited partnership. All these categories are known as body corporate only. Even though it's a partnership firm in that country, it is not partnership firm as per this definition. So there establishing again majority stake is a challenge. That is there. Case to case basis we have to examine and take a call.
No, even Indian company also, another company, maybe unless they declare their relative or some person, indirect control, how we can establish?
Exactly. Ultimately it is their declaration only.
Ah.
Their declaration only, self-declaration only. That's why these provisions, if you see the last provision, misleading, it's their responsibility to correct information. Okay. They should give. The company is having a limitation. You cannot go beyond certain limit to establish. By any chance, if they know that there is a relationship, that definitely we can send a notice and all.
So similar concept is applicable for LLP also?
LLP they have made, they are, some of the provisions they have, last year there was an amendment. Many provisions like disqualification, some of the provisions, this also, you are right. It is made applicable to LLPs also. But there is some little bit of ambiguity is there. But it will come. It will come.
Is there any form to be filed for not having the SBO?
No.
No.
No. Nothing.
in the website, in the NCA website, like we try to find out the director's details by putting the DIN number or the SIN number of the company, we get the company details. Is there a mechanism to put the SBO number and get the details
No.
extract?
No such option.
No such option.
No such option. No such option. Okay. That's all. Okay. Thank you for patient listening, and definitely you are very learned audience, I would say. Thank you so much for the opportunity.
Thank you, sir.
As a saying amongst professional goes, if you are not updated, then you are outdated. SBO declarations, a new concept and provisions introduced, which needs to be updated. With that basic idea, the study circle meeting was planned. And to handle the new topic, only a professional who is having a passion towards teaching and disseminating the knowledge. A big round of applause for CS Vivek Hegde for his deliberations on the subject. He, if I can say, tried to lift the corporate veil of the topic, SBO declarations today. On behalf of members present here and all the managing committee members of Bangalore branch, we wholeheartedly thank you, sir. Can I request CA Vijay Kumar, sir, to come out to dais and then hand over a memento to speaker as a token of gratitude and respect? Thank you, Vijay sir. Thank you, Vivek sir. Thank you one and all. And I wish each one of you happy Sri Krishna Janmashtami. Thank you. Keep supporting Bangalore.